So today we're more or less 4 years after the entry into application of GDPR. I'm going to present briefly how GDPR enforcement is faring and the experience of national data protection authorities in cooperating on cross-border cases. And my goal is really to explain the day-to-day practice of DPAs in the 30 European countries, as well as their joint experience as members of the EDPB. DPAs play a key role in safeguarding individuals' data protection rights. They help individuals enforce their rights and exercise the corrective powers when appropriate, both at the national level and also in cross-border cases. The enforcement, you've probably seen it at national level, is increasing steadily. For instance, the fines that were adopted last year in 2021 amount for a total of 1.3 billion euros, which is more or less 5.5 times more than in all the history of GDPR before. And some of these fines, of course, concern cross-border cases that are adopted by the so-called one-stop shop mechanism. Excuse me. Under the one-stop shop, as you know, the lead supervisory authority, or LSA, is the sole point of contact for the controller of the processor that is involved in the case. And the concerned supervisory authorities, the CSAs, are the points of contact for the data subjects in the member states. The LSA is in charge of leading the cooperation process. It shares relevant information with the CSAs. It handles the case in cooperation with the CSAs, prepares the draft decisions, and tries to reach a consensus with the CSAs. Just a couple of figures for you to keep in mind. In the past 4 years, we've had more or less 500 or 600 cross-border cases per year. In total, there's 2,000 cross-border cases, more or less, in history of GDPR. We've had more than 1,000 one-stop shop cases where the one-stop shop mechanism was applied. And out of these, there's been already over 380 cases where final decisions were taken. In most of the cases, there's a consensus. So they're resolved by consensus, meaning agreement between the LSAs and the CSAs. But sometimes, and this is normal, the authorities are not reaching a consensus, and in that case, the EDPB will step in and adopt the so-called binding decision to resolve the dispute. One important thing to keep in mind is that, by definition, these decisions are on complex cases. So it's cases for which authorities have been working together for 1 or 2 years, or sometimes more. They haven't reached an agreement, and the EDPB has to decide in a very strict legal time frame, which is imposed by GDPR, and settle the dispute between these authorities, because afterwards we have a binding decision for the lead authorities. And the decision may increase or reduce the fine, for instance, if it's about a fine. And as you know, some of these cases are about big fines, because sometimes you talk about several hundreds of millions of euros. So the decisions have to meet a very high level of quality, because they're going to be challenged. We have a case, for instance, with a binding decision that was adopted by EDPB that is being challenged both before the National High Court of the lead authority that took the decision, and also before the Court of Justice of the EU, because they're challenging the binding decision of the EDPB. So it's a super high responsibility. We work within very tight deadlines and on very complex issues. So this is when EDPB basically is stepping in.